I'm Gary Burgess, and welcome to Holding Court, the Jersey Law Podcast. I'm joined by my friend and expert advocate, Rose Colley, partner and family law expert at Vibus. Rose, good to see you.
Good to see you too, Gary.
So much of family law to explore. This time, I thought we'd focus on financial settlements, because as people are going through perhaps a separation or a divorce process, as much as we don't like to think about it, so much evidently is focused on the finances. And I imagine that can be a real bone of contention for people.
Often the biggest bone of contention.
So
It's all about the money.
So how do you go about starting that process? Because if people are coming into it thinking, I want my unfair share, that is human nature, how do you achieve whether it's parity or fairness or simply an outcome that both sides agree to?
Well, what you have to do, first of all, is you have to decide what is in the pot. And I tend to explain to clients that on this side, you've got what's called the capital pot. And in the capital pot, some things will be completely liquid, like money in your bank, investments. Some things, usually property, will be not currently liquid, but can be liquidated by selling it. And then you have things that are completely illiquid. And these tend to be the things that can cause the difficulties, such as pensions, for example. Also, assets within company structures, maybe a trust structure. So you have the capital pot and you have to work out what is in that pot. And sometimes that process is very easy. Sometimes it is more difficult than it should be. So, for example, if you're not going to sell the house but you want it valued, you send along 3 different estate agents and they come back with 3 different figures, when what you want is for them to all come back with the same figure, but it just never happens. And then you have to agree normally to take the midpoint, which may or may not be the real value of the asset. But you do have to value everything, including things like pensions. Some things are very difficult to value, such as if you've got a discretionary interest in a family trust. How on earth do you ever begin to value that, particularly if the trustees say, no, you're not going to have this information? That can cause real complications. But then you have an income pot, and the income pot is usually easier to ascertain. The difficult cases on income are where someone is usually self-employed, because you can't believe how often they're not making any money at all. Then you have to look at their lifestyle, and you can't believe how often they say, I owe the taxman £100,000, but there's no evidence of it, for example. So on the face of it, working out someone's capital and income should be straightforward. And in some cases it is, but in lots of cases it isn't straightforward at all.
It sounds to me that there's a real element of detective work on your part to try and get this information. Forensic work, absolutely. But in practical terms, how do you go about that? Are you liaising with the lawyer for the other side? Are you demanding from them greater transparency? Or can this be dealt with at a slightly more informal, friendly level? How does it work practically?
It depends. To get a good idea of the pots and the lifestyle that the couple have been enjoying together, you do need to look at things like bank statements. In fact, the thing that tells you most about lifestyle is often credit card statements. So you have to do a certain forensic analysis of those. You have to check to make sure money isn't going in from another bank account, for example. I think through the process, you will learn quite a lot about the couple's finances. And then there's an opportunity to ask questions. So, for example, if you bought a piece of jewellery that cost £6,000 during the period of separation, and it obviously wasn't for your wife or husband, you then ask questions about things like that.
And I imagine the process of doing that
is expensive.
And also in danger of opening up perhaps fresh wounds that potentially the other half of this relationship may not have known anything about.
No, that's true. Sometimes they won't. Obviously, very often the wife or the husband, although usually, in fact, in reality, it's the wife, she doesn't have a clue what's on, for example, the husband's credit card statement. She never sees them. And now she suddenly sees them and she realizes, and I've had this happen to me a few times, that 2 years ago, when they were happily, she thought, living together, he was staying in a hotel with somebody else.
What's the best approach at the outset to get the best outcome? Is it transparency on the basis that if you think you're being clever right now, actually the truth will come out, so better to do it sooner rather than later?
The best way is transparency, because if you're not transparent, then eventually it will come out, but it may have cost you and your partner maybe £10,000 to get to that point. An example of how far sometimes people can take things is that, again, probably a couple of years ago, we were trying to find out if a pension could be liquidated. And we had a pretty good idea that a lump sum may have been paid out, but there was nothing in the bank statements. So we then got leave of the court to write to the trustees of the pension scheme, who then came back and were about to confirm that they had paid out. And then the husband in question suddenly said, "Oh, yes, I did have a lump sum, quite a large lump sum, but I paid it to my new partner's bank account." And of course, if we hadn't have gone through that forensic exercise, that case probably could never have been resolved, because on the face of it, there wasn't enough money. But with that extra money, then it all started to fall together.
And effectively changed the game of that story with that extra piece of the jigsaw puzzle. Yeah. You mentioned the courts there, Rose. At what point do the courts get involved in this process?
Okay, well, the court can be useful for setting timetables. There are some cases, and I would say 20-30% of cases, where they sort everything out themselves with some help from lawyers as to what a fair settlement will be. Then there's probably the next 50% of cases where you need the court to impose a timetable. So you simply apply to the court. It's a very quick document saying, "I want the financial timetable." The court will make that, including all of what's called disclosure, which is all the financial information. And then hopefully you can resolve things. And then it's the remaining, I think we've got about 20% left, where you need the court at every step of the way. So you might need the court to make an order for interim finances. So whilst this process is going on, because if one party doesn't have an income and the other party decides that they're not going to pay him or her anything, then you need to make an application for what's called maintenance pending suit, which sounds very old-fashioned, but it's just interim maintenance.
And actually, the court does have the power to do that. So if somebody, as this relationship is breaking down, suddenly finds themselves with nothing, and the other partner
and that does happen,
has everything, the court can intervene to, I guess, create some semblance of fairness in the meantime, pending the final resolution.
What has to happen is that you have to work out your relatively basic, what are called interim needs for that period, often for, let's say, the next 6 months. And then the court will make an order that so much maintenance is paid. You can also use that process if there's enough money in the pot to get the other party to pay something to you by way of legal costs as well.
Is the assumption that the outcome is 50-50? How does it work? What is the magic formula? Indeed, is there a formula?
The answer is there isn't a formula because it's all very discretionary. Every case is different, but there is case law both in England and here, and in family law in Jersey, we tend to look to England to their case law, although it's not absolutely binding on the court here. But there is a starting point of 50-50. But having said that, very, very few cases end up 50-50. So almost certainly if there are younger children, the eventual capital breakdown won't be 50-50. And very often it may be the sort of case where other factors like inheritance may or may not be taken into account, or usually needs will move it away from 50-50. But the 50-50, and it's really important to remember this, is only the starting point for capital. So on the capital side, let's say we've got a capital pot of £3 million. The starting point will be 1.5 each, which may be fine. But if the starting point is 700,000 in the capital pot, then where, for example, there may be one or two young children, 50-50 clearly isn't going to work.
I get you. That makes perfect sense. How long does or can this process take? I imagine it's how long is a piece of string because they're all so different. But in a case that feels like a routine divorce, is there a guide that this is a matter of weeks or months or years? What can I expect?
If you were looking for beginning of the divorce and starting to talk about finances, to the worst case scenario in terms of going to a final hearing, then you're probably, I would say on average, talking about 10 months to a year.
Oh, goodness.
Some cases longer, but the courts more and more are now streamlining their processes and the time is actually getting slightly shorter. So I would say average of around 10 months to a year.
And is there a way of avoiding that court process?
Yeah, there are a number of ways of avoiding that court process, and this is all sort of called alternative dispute resolution. So the first thing is you have to know what's in the pot, because obviously there are capital needs and there are income needs. So you've got to agree both capital and income. So you can do it through a process of, first way is obviously just exchanging information and letters between lawyers. I find very often that doesn't work and can actually make the process longer than it needs to be. You can then have what are called roundtable meetings, which is lawyers and clients sitting around a table, or you can then use the more formal types of dispute resolution, which more and more in Jersey involves something called an FDR, which is a financial dispute resolution. And there are two ways of doing that. One way is relatively new, and that it is now possible that if you have proceedings before the court, there are two family registrars or judges, and the one of them who's not dealing with your case can bring you to a financial dispute resolution where they can't make decisions and they can't hear evidence, but they will say, given what I can see and what I've heard, if I were the judge on this case, this is what I would order. So you can either do that with one of the judges here, and that's really, really good and useful, certainly for the sort of middle capital type cases, middle income type cases. Or you can bring someone in from usually London, who practices family law in London, usually a barrister. Usually they're sitting as a judge part-time in London as well. And they will come over and they are excellent in terms of what we call the bigger money cases, where you're looking at complicated company structures, trusts, for example, perhaps quite difficult partnership arrangements that you may have with your partners as the husband or the wife as well. And all of those ways can be really, really successful. And certainly over the past year, of all the cases I deal with, I've only had one case that went to a final hearing, but probably 10 cases that were resolved through particularly the financial dispute resolution model.
And why is it these FDRs, these financial dispute resolutions, work? Is it that just people don't want to have got to that final hurdle of the judge having the final say in court? They like to feel that they've not needed that ultimately?
I think primarily for three reasons. One, the judge sitting at the FDR will say, do you two lawyers agree that if this goes to a final hearing, it's going to cost on average another £60,000, which can be a big okay moment.
Wow.
We probably need to sort this out. Two, he or she as a judge will say, this is what I think your judge will decide. And usually they are just about spot on.
Sure.
And then that makes both clients, I think there's a lot at risk here. And then there's the third reason that you touched on. You know, I often say to clients, this won't be your decision. It will be the decision of someone you've probably never met, will never meet again. And there's always a risk that your wife or your husband will decide to be really difficult and appeal the decision and cost even more money. And then, you know, you're £200,000 worse off.
You have been using some eye-watering numbers in our conversation. What are the costs around this when it comes to achieving this financial settlement? As I go into that process, I want to go in with my eyes wide open. What should I really be expecting?
And this is a question that clients often ask. And what I say to them is that normally the average case will cost probably between 5 to 15,000 in legal costs to sort out the finances. And then it really goes up from there. The more complicated the issues, the more people argue about things, the more you may well get disputes about children that also creep in that tend to add to the costs as well. Then you're beginning to get into the 50, 60, 70,000 pounds. Very, very few cases more than that, but they tend to be the cases which involve a lot of money. But even then, it's still a lot of money to pay £100,000 in legal fees, even if you've got, you know, multi-millions in assets.
Because it's 100,000 taken out of that pot that was available at the start of the process. Be honest with me, Rose. How much of these eye-watering sums are about complicated cases and how much are about people frankly being stubborn, and perhaps it's only after it's settled they can look back with that perfect science that is hindsight and go, do you know, if I had my time again, perhaps I would have approached this differently?
I think it's a combination. You know pretty early on if the husband, the wife on the other side is going to be upfront about the finances, so you know what's in the pot. Often you can tell pretty early on if your client is accepting that certain assets have got to be shared. That can sometimes be a real problem. So yeah, that's how the costs tend to mount up. And I think there's sometimes a gradual realization that things do need to be resolved, but it may take several months and it may be at a certain amount of cost.
And if you've gone quite a long way down this process, it's never too late to go, let's pause this and agree and settle now. That can be done at any time.
And that happens a lot, and it can happen at any time. I mean, it can happen. I was reminding myself of a case the other day where the finances were settled, I think, 2 days before a final hearing, which was silly really because you've done all the work for the final hearing, so the costs that you saved were probably minimal. But at least the couple knew that they had agreed things themselves. And that's what's so important.
Let's wrap this up with 3 key takeaways. If you could give your 3 best pieces of advice for a couple embarking on this journey and they've no idea how long or difficult or complicated this journey is going to be, what are the 3 things you would advise them up front to make this as painful as painless as it could possibly be?
I think firstly, be completely honest about what the finances are. So, for example, if you are expecting a bonus this year, then tell your lawyer who can disclose it. If you are able to take a lump sum from a pension, then disclose it, because lots of people don't do either of those things. I think that's the first thing. Secondly, I think be realistic in that something we haven't really touched on is that most cases are needs-based, so they may not end up as 50-50. They may end up as more like 35-65, 60-40 in terms of the split. And it's just accepting that that may well happen in many cases. So I think it's this realization that you do need to be prepared and realistic. And I think probably the third thing is to think at each stage, how much further shall I push this in terms of the benefits that I'm actually going to reap at the end of the day? So it's, if the lawyer gives you the opportunity to try and settle things, think through it really carefully and try and make good and realistic offers.
Always good advice, always sage advice, and that's why you are the family law expert and partner at Violet. Advocate Rose Colley, thank you so much.
Thank you, Gary.
And join us next time as we're holding court, the Jersey Law Podcast.